Okay, well, hello everyone. Thank you for joining us. My name is Jarell Hunt. I am an attorney in the Financial Services Practice Group at Tonkon Torp and would like to welcome you to our webinar, Managing Investment Advisor Compliance in the Global Pandemic. Our hope is to provide you with practical advice for your investment advisory business to thrive during this pandemic. If you have questions that are unique to your business, we would invite you to reach out to our panelists directly or the Tonkon Torp lawyers you normally work with to discuss your specific situation. Today, we will be hearing from three speakers: myself, Jarell Hunt, Jessica Morgan, a partner, a partner at Tonkon Torp and a co-chair of the Financial Services Practice Group, and Chris Pallanch, a partner at Tonkon Torp and the other co-chair of our Financial Services Practice Group. Let me pause and make a note about this format. First, please know that we are actively recording this webinar. You do not need to sign a disclosure and no private information of yours will be shared. Please know, however, that if you choose to participate in our Q&A session, your question may be recorded in association with your name. Feel free to submit questions in the Q&A section of your Zoom app. We will do our best to reach each panelist. We will do our best to ask each panelist a few of the questions as they come up, but we want to be sure to have enough time for all panelists. So if your question is not asked right away, please wait for the end. Because the situation is so rapidly changing, we may not know the answer, or your question may be too nuanced or specific for us to address in this webinar format, in which case we would welcome you to reach out again to one of our panelists today or the Tonkon Torp attorney you usually work with. We will conclude today with a Q&A session and we'll try to hit as many of the questions as we can. We welcome any feedback you may have after this webinar. If there are topics you want to hear about more, please tell us. We hope to be a source of information for our business community throughout this challenging time and plan to hold additional webinars going forward. Finally, the information presented today is as of May 6th, 2020 and is not intended to be legal advice. Let's start the program. These are today's panelists. Sorry for missing that before. So we'll get started with an overview of Form ADV and how its filing has been impacted by COVID-19. Form ADV Parts 1 and 2 are normally due within 90 days of an advisor's fiscal year end, but this year in March 13, the SEC issued an order under Section 206A of the Advisors Act offering temporary exemptive relief from certain filing and delivery requirements related to Form ADV Parts 1 and 2 and Form PF for advisors affected by COVID-19. On March 25th, the SEC issued another order which superseded the March 13th order and, among other things, expanded the scope of advisors that qualified for the relief. The March 13th order provided relief only with respect to Form ADV deadlines and delivery obligations between March 13th and April 30th. The April 30th end date was extended to June 30th in the March 25th superseding order. For advisors with deadlines within this window, the orders require the advisors to meet the filing or delivery requirement as soon as practicable, but in any event, not more than 45 days after the original due date. For example, advisors that are taking advantage of this relief who ordinarily have a March 30th filing deadline will need to file Form ADV Parts 1 and 2 next week. The relief also came with several conditions, some of which were removed in the March 25th order. To obtain the relief, first, advisors must be unable to meet the filing deadline or delivery requirement due to circumstances related to the effects of COVID-19. The advisors must also promptly email the SEC at iardlive@sec.gov and disclose on its website that it's relying on the order for the exemptive relief. If advisors do not have a public website, then they are required to provide notice to their clients and/or private fund advisors in lieu of the website disclosure. The March 13th order had also required advisors to include in the email a description of the reasons why they weren't able to meet the obligations and an estimated delivery date or an estimated date by which they would they expected to meet the obligations. The SEC had a change of heart, however, and in the March 25th order, ultimately removed these two requirements. So you'll see them stricken in this slide. The SEC's Division of Investment Management has also commented on how the order relates to advisors participating in or sponsoring wrap fee programs. And so this is important for those on really either side of the wrap fee program. And with respect to any clients that temporarily or exclusively interact with the participating advisor through the wrap fee program sponsor, the staff suggested that the sponsor also consider posting on its public website notice that the participating advisor is relying on the order to further inform those existing clients. Now, this is in addition to the participating advisor providing the notice on its own website. And the staff also suggested that a wrap fee program sponsor could provide the requisite email mentioned above on behalf of the participating advisors if in the email the sponsor identified each individual participating advisor that is relying on the order and represents that it has authority to submit the email on behalf of those participating advisors. If the participating advisor is also relying on the order with respect to any clients for which the sponsor is not contractually obligated to deliver the brochure, however, the participating advisor would need to separately satisfy the notice condition. So to make sure that notice is being provided to and with respect to all necessary clients, we recommend having both the sponsor and the participating sponsor provide notice where applicable. This is really just to avoid any notice falling through the cracks. Now, pivoting to the private fund space, I'll just briefly note that private fund advisors have to provide a similar email, but it's just to a different email address. So note that it's formpf@sec.gov instead of the IARD website. And then before moving on, I'd also just like to note that OC has already come out and stated that reliance on regulatory relief will not be a risk factor utilized in determining whether OC commences an examination of an advisor. So hopefully this provides some comfort for those who were a bit hesitant to rely on the exemptive relief. Now, shifting from filing and delivery to substance, there are a few ways in which the current pandemic may affect information that goes into your Form ADV Parts 1 and 2. First, Form ADV Part 1A, Item 1F, requires an advisor to include information about its principal office and place of business. And although this may seem to have changed in the current teleworking environment, advisors do not need to update this item solely because employees are working from home as part of the firm's business continuity plan in response to COVID-19. So if you're teleworking now just because of COVID-19, you do not need to go back in and update Item 1F. Second, Form ADV Part 2A, Item 8 requires discussion of risk of loss. For example, you would discuss material risks involved if an advisor recommends primarily a particular type of security. And although not all advisors will need to include risk-related information due to the market effects of COVID-19, we do recommend that advisors consider whether and how the current environment may be disclosable as a potential risk on their Form ADV. For example, it may be appropriate for advisors that extensively use equities that have been especially volatile or otherwise affected by COVID-19 to include information on that here. Again, you would want to have a discussion with one of the panelists or a Tonkon Torp attorney that you regularly work with to see whether and how this relates to your specific situation. And then third, advisors who received PPP loans or other financial assistance may need to disclose the nature, amounts, and effects of the assistance on Form ADV. The SEC provided guidance on this topic in response to the PPP loan program, but the guidance included more broad reference to other financial guidance, suggesting that other types of financial assistance may also need to be disclosed on the Form ADV and potentially opening Pandora's box. The guidance cited the need for fiduciaries to make full and fair disclosure to clients of all material facts relating to the client relationship. And this really comes down to the financial condition of the advisor leading up to the financial assistance. So the guidance included 2 questions to consider. And the first is whether financial assistance was needed to pay salaries of employees who are primarily responsible for performing advisory functions. And second, whether the firm is experiencing conditions reasonably likely to impair its ability to meet contractual commitments to clients. And if the answer to either of these questions is yes, advisors should consider disclosing the financial assistance on Form ADV. And again, that would be participation in the PPP loan program, but also potentially other financial assistance obtained in response to COVID-19. Now we'll touch just briefly on a few miscellaneous COVID-19 related issues. First, COVID-19 has impacted the custody analysis. In normal times, advisors who inadvertently receive client securities will have 3 business days to return the securities in order to avoid custody. The SEC has acknowledged that this presents challenges in a teleworking environment and clarified that if personnel are unable to access mail or deliveries at an office location due to the firm's business continuity plan in response to COVID-19, then the advisor is not considered in receipt of the client assets until firm personnel are able to access the mail or deliveries at that office location. And then secondly, the SEC has offered some guidance with respect to delays in surprise examinations from COVID-19. Specifically, if an independent public accountant engaged to perform a surprise examination did not complete the examination and submit Form ADV-E within 120 days after the date chosen by the independent public accountant due to logistical disruptions from COVID-19, there will be no violation of Rule 20642 as long as the report is filed as soon as practicable and not later than 45 days after the original due date. So again, here the SEC is offering, it went with the as soon as practicable language, but put a 45-day cap on the extension. And then lastly, I just wanted to mention the Division of Corporate Finance of the SEC offered some guidance on March 25th regarding COVID-19 related disclosures in certain filings. And this guidance focused largely on the need to disclose ways in which business and operations are or may be affected by COVID-19 in financial statements and other filings that are made under the Exchange Act. And although this may not be directly applicable to all of the advisors that are here in attendance, it does tie back to the previous discussion of disclosing risk of loss and confirms in another way that the SEC really wants to see disclosure around potential future impacts of COVID-19. So if your business is if you're expecting significant business disruptions going forward that might impact your client relationships, we're viewing this as just another more confirmation that the SEC wants to see that disclosed. And we'll pivot now from Form ADV to Form CRS, which is also known as Form ADV Part 3. This is a new requirement, but hopefully already on your radar. The requirement is for broker-dealers and investment advisors who have retail investor relationships. We're currently in the initial filing window, which began May 1st and ends June 30th. And the form can be no longer than 2 pages, 4 pages for dual registrants that are electing to file a single form, and requires specific language and information in certain instances. And the length restriction can present some challenges for advisors and BDs with complex business models, but the SEC has given some flexibility for those advisors and BDs who need additional room. For example, the form can have click-over language or provide links to web pages with additional information. Advisors and BDs are required to include the current version on their public websites in a location and format that is easily accessible for retail investors. So right now you should be hopefully wrapping up the form or at least working on it. And then once you're done with it, you need to start thinking about where you will put that on your website, and then some delivery requirements that I'll speak to coming up. And then as mentioned previously, the substance and delivery requirements for Form CRS have been unchanged by COVID-19. So let's take just a quick look at what information is included in Form ADV-CRS, which is comprised of 5 items. Without getting into too much detail here, I just want to note that items 1 and 5 are really little more than inserting the filer's name and some contact information, in addition to some brief specific language that's actually required by the form. So for filers without any disciplinary history, most of the real meat of the form falls into items 2 and 3. And if you'd like to discuss the substance of Form CRS in further detail, please feel free to reach out after the presentation. But for now, I'd like to pivot slightly to the delivery requirements of the form. So the form needs to be delivered to both new and existing relationships as of going forward. So let's start first with new customers who are retail investors. Advisors will need to deliver the form before or at the time they enter into an investment advisory contract with a retail investor. Now, you should note that this does include oral agreements. Broker-dealers are required to deliver Form CRS before or at the earliest of making any recommendation, placing an order, or opening a brokerage account for a retail investor. And if you're a dual registrant, so both a BD and an advisor, then you would need to deliver Form CRS at the earlier of the above requirements. Now we'll shift here to existing client and customer relationships with retail investors. Advisors and BDs need to deliver Form CRS within 30 days of the date by which they are first required to file the form. And then additionally, advisors and BDs will need to provide the Form CRS to clients and customers who are retail investors before or at the time they either open a new account that's different from the retail investor's existing account, recommend a rollover, or recommend or provide a new brokerage or investment advisory service or investment that does not necessarily involve the opening of a new account and would not be held in an existing account. So the best example here is if you're recommending a first-time purchase of a direct sold mutual fund that's not going to be held directly within the account, then you would need to deliver the Form CRS again. And then lastly, you need to deliver the Form CRS within 30 days of a retail investor's request for the form. And then lastly, I just want to touch on what updates to Form CRS look like. Advisors and BDs need to file updated relationship summaries within 30 days whenever any information becomes materially inaccurate. Now, advisors out there should note that this is more stringent than updates to Form ADV Parts 1 and 2, which only require other than annual amendments for certain changes. So here, you really need to think about if any of the information is materially inaccurate, that automatically is going to trigger a Form CRS update. And the updated filing must include an exhibit that highlights the changes being made. Then in addition to filing the updated relationship summary, advisors and broker-dealers must communicate changes in the updated relationship summary to retail investors who are existing clients or customers within 60 days after the updates are required to be made and without charge. So there's kind of a two-step process if it becomes materially inaccurate. First, you need to update the form and then file it. And then secondly, you need to get the word out to those existing retail investors. The SEC has clarified, however, that you can deliver the information through another disclosure that's delivered to the retail investor. So if you are making these changes around the same time as you're providing other disclosures to a client, you can think about ways to sort of consolidate the notice and try to avoid having to send out separate mailings, which hopefully alleviates some of the burden. Well, that concludes my portion of the presentation. And I would now like to turn it over to Jessica Morgan.
Thanks, Jarell. This is Jessica Morgan. Hello, everybody. It's nice to see some of your names on the attendance list. Unfortunately, I can't see you in person, but maybe next time. What I would like to focus on right now is some of our, and I can't shift, there we go. some of the policies that you should be looking at, your compliance policies that should be getting updated. Recently, the OCIE has conducted a sweep exam letter prompted by COVID-19. It confirms that examiners have been requesting copies of firms' BCP and related PPPs and looking for how the plans are specific to pandemics. They've pledged that they are fully operational nationwide, and that given the status of the pandemic, has moved to conducting examinations offsite through correspondence unless absolutely necessary. It's not uncommon for the OCIE to reach out during times of a crisis in order to better monitor the markets and understand market risk at a macro level. However, it is important that every investment manager prepare for this type of outreach in advance. The best way to do that is to review your current BCPs and have a disaster recovery plan if you don't have one already, and identify things such as your locations where your data is backed up, documenting your compliance with your BCP plan, revising your BCPs to fit the current pandemic, and checking with your vendors on security information. The next policy that I'll talk about is the insider trading policy. Although other rules may be relaxed during the pandemic, the insider trading risk remains a top priority for the SEC. The SEC directors have announced their focus on maintaining integrity and following corporate controls and procedures. They are specifically devoting substantial resources to insider trading review. Along with that, they've created a marketing task force in which, in addition to other things, they'll be looking for market anomalies. They've termed this as unique circumstances, and in such unique circumstances, they are expecting that the circles in which information is disseminated is going to grow and expand to include people and information that is not normally included. What advisors can do during this pandemic is to review who in your organization has access and needs to be cautious with the information. Specifically, your directors, officers, employees, and consultants should be mindful of your obligation to keep information confidential. The training and on policies and procedures should be done. You have teleworking opportunities right now with your webinars, and it would be great timing to do some training on your policies and procedures, specifically on the insider trading policy, to keep everyone mindful of what their obligations are to keep information confidential and to comply with the prohibition on illegal securities trading. Redefining the nature of what material information is important right now. This means that CCOs need to look beyond mid-level management for insider trading, since any number of frontline workers could potentially have material information that would be wealth defining. Moving on to custody, I know Jarell mentioned a few of the changes, but it does continue to be an exam priority. And from the OCIE's top exam priorities, it continues to be an issue, and specifically the focus on whether or not firms are compliant with their 2017 no action letter and the 7 conditions for compliance with SLOAs. Recently, though, the SEC has waived certain steadfast rules, which Jarell mentioned, including surprise exam timing and the ability to hold on to checks for an additional amount of time. Further, in the event that custodians are unable to accept physical certificates, advisors may hold on to them so long as they meet certain requirements. For instance, the certificate is restricted in that the consent of the issuer is required in order to transfer it. Ownership of the security is recorded on the books of the issuer or transfer agent in the name of the client. The physical certificate bears a legend restricting transfer. You're getting the picture that you have to be restricted on transferring. And further, the physical certificates are appropriately safeguarded and can be replaced upon loss or destruction. The other thing that you need to do is to make sure that you keep a record of the custodian's closure. And if you do that, then you can maintain compliance. Really, it's just about documenting if that in fact does happen during this time period, and you need to keep track of your potential compliance violations. With respect to surprise exams, I would note that if you have any excluded accounts from the exam, then you should have appropriate documentation to prove why they can be excluded. Further, you need to make sure that you know why you do or do not have custody. Examples: ability to deduct fees, power of attorneys, acting as a trustee, or any additional access that you have. You need to be able to prove to the examiner that you have a thorough understanding of what the rule allows. And recently, due to the number of revisions and additional guidance that the SEC has provided on the custody rule, it is no surprise that they are considering rewriting the rule in the next year. So we will keep you updated on that. Specific COVID considerations on other policies are your CCO policies, your supervision policies. There are now considered red flags if your CCO is being shared with other firms and how many other firms your CCO is engaged with. Further, how often does your CCO designee change? So on your Form ADV, are you constantly making changes to who that person is? Those are now being flagged for review by the SEC. The next policies that I'll talk about are your HR policies and handbooks, which should be reviewed if you haven't already. I'm guessing that during this time, you've already had to implement a lot of different policies and procedures and guidelines for your employees. And any of those need to be documented for the SEC. They are specifically looking at how you handled changes to your organization during this pandemic and what those changes are. And if you haven't already implemented policies related to the outbreak and remote working, then we, Tonkon lawyers, have been providing this information to our clients, and we have a lot of information and literature that is available on our website, and we can provide you with contact information on the other issues. Some of the things that you may have heard about over the last few months, the last year, on certain actions that the SEC was going to take but hasn't come out and said anything specifically, are these 6 pending items that were supposed to have been cleared up within the next, or should have been cleared up by May 1st, but now have been delayed past May 1st. Some of those include the accredited investor definition. If you weren't aware, that definition is being reviewed to be more expansive. The use of derivatives by registered investment companies, prohibitions and restrictions on proprietary trading with banks, and then some others are what qualifies as an independent accountant, payments by resource extractions, and new, our new national market system plan. Specifically, though, as it relates to the advertising and solicitation rule, those comments were received by the deadline in February. The SEC received 72 comment letters, and the summary of what they found are highlighted here. The focus on allowing testimonials. There was a lot of concern by the investment advisors that responded allowing testimonials will bring down the credibility of the investment advisors, and so that is being discussed as a potential revision. The definition of what is an advertisement, apparently everyone felt that it was too broad, and that the SEC needed to provide further definition as to what is an advertisement. What will be required for a review? The commenters requested that the SEC provide what they would look for as appropriate approval mechanisms. And then other changes that were noted not by a majority, but specifically highlighted as potentially going to affect the further revision of the rules are the recommended policies and procedures safe harbor, so that the SEC would put out its own set of policies that you were intended to comply with, and that if you adopted those policies, that would provide you with a safe harbor. The use of social media was requested as being updated to give guidelines on what was appropriate and how to use it and when to use it. Performance reporting was something that everyone would like further guidance on, and as well as hypotheticals being used in your advertisements, and it mainly being highly discouraged. And next, we're going to go to Chris Pallanch. Chris, are you there?
There. Now can you hear me?
Yeah.
And now can you see my screen? I hope that I have got that up. Hold on. I apologize. Jessica, can you hear me?
Yeah, I can hear you.
Great. I just finished a hearing with the court, and so usually I'd have to run from the courthouse back over to the Tonkon offices to start giving the presentation. And now instead, it's just supposed to be clicking from one computer over to another. But as it turns out, there are still difficulties always when you're in the run from one to another. Can you set it up so it's sharing from my computer, please? I've got the deck ready to go here.
I think you just have to click on share screen.
Perfect. Maximizing this. Here we go. And now we're going through Jessica's and finally on to this. We all set? Good?
All set, yes.
Thank you. So to quickly set things off, I'm going to talk briefly about examination priorities, then we'll talk about Reg BI, and then we'll wrap up with just a couple of points to consider from recent enforcement actions and activities. First, OC issued its exam priorities on January 7th, and by and large, those have remained unchanged year over year. And we will see some changes, we think, coming along as a result of COVID, but we don't yet know exactly how that's going to roll through, which we'll talk about in just a moment. But generally speaking, the examination priorities are going to be the same. We're going to be looking at disclosures of fees, expenses, and conflicts. We're going to be looking at making sure that there's compliance for entities that provide critical services to the capital markets. There will be a focus on cyber and other security risks. And that one in particular, we'll talk about in a little bit, but with respect to some phishing scams that have come up with recent coronavirus activities, I think that's going to be a big priority, even more so than it would be anyway, if there's going to be, when there are examinations. And then there will continue to be the risk-based examinations for RIAs, RICs, BDs, community advisors, continued compliance examination for anti-money laundering rules, digital assets and robo-advisors, and then the self-regulatory organizations, especially with FINRA. And really, the matters of focus that we're going to see that I'm going to talk about right now will be Reg BI, Form CRS, which I believe was covered earlier, and then a continued focus on new types of investment strategies and alternative data use and third parties who provide that data. So turning now to Reg BI, the SEC is going to begin examinations for it on July 1st, 2020. And this deadline will not be further pushed back, even in light of any other developments, at least as far as I know right now, with the caveat that the focus is going to be on how people are actually drafting their supervisory procedures, both before, during, and after their transition to Reg BI. OC issued a risk alert on this topic in April of 2020. And the big takeaway that we think we're taking from this is going to be that the focus of the first year isn't going to be so much on strict compliance, but it's going to be on whether or not folks have implemented policies and procedures that are reasonably designed to achieve compliance with regulation best interest. Now, this is by no means supposed to be a free pass, but what the guidance appears to be is that they want people to be making their best efforts to try to comply with Reg BI. And that if you're making good faith efforts to modify policies and procedures or to enact the PNPs, that will get you much farther than if you just ignore it naturally, right? But for the first year in particular, strict compliance may not necessarily be a result for a major finding, so long as there are good faith efforts made that are reasonable in the circumstances. So included in that April 2020 risk alert were 4 primary issues. The first was that they want to make sure that there are going to be disclosures, and that in particular will relate to material fees and costs, investments material limitations, and in what capacity a BD is making recommendations. Second, there will be a care obligation, as everybody here is probably aware, and that's going to be looking at the reasonable diligence, care, and skill when making a recommendation to a retail customer. And then that also has to be considered with the potential risks, reward, and costs of a particular investment. Then you have to weigh those factors in light of the retail customer's investment profile and make a recommendation that's then in the retail customer's best interests. So the third issue that Reg BI will be concerned with will be conflicts of interest. And once again, this is going to be a matter of making sure that you've got written policies and procedures in place that are going to be designed to deal with conflicts of interest associated with recommendations that may be made. So the critical point, one more time, will be just having the policies and procedures, then after you have them, follow them. Fourth, compliance obligations, and this is going to be having policies and procedures designed to ensure compliance. And this ties back in with the first point that we made about OC's expectations in particular for the first year. So the takeaway is make a good faith effort to comply, and then have focused documentation on delivery and filing, content, formatting, updates, and record keeping. There will also be, we're sure, or at least we're very hopeful that there will be additional SEC updates. There was an FAQ for Reg BI, and we will continue to check for additional updates as those come down the pike. And there is also entity compliance guidance released by the SEC. Moving on now to talk about some recent enforcement activity. And I believe Jarell talked about this earlier, or Jessica might have covered it as well. Some of the recent happenings, we'll look at kind of happenings and activities and then actions. First will be disclose PPP money to clients if it's going to have if it's a material fact that your advisory clients would want to know. Second, there's going to be some extension of time to conduct quarterly securities. I guess I have that as third. And then next, there will also be some additional time to make sure that hard checks are sent or received in timely fashions for those people who may be doing transactions with customers on the check basis. With respect to enforcement activities, the SEC in general, and then the Office of, and then OC in particular, is trying to make sure that people know that this is not a time to run out and try to flout the rules. And instead, since March 10th, the SEC has been working in what it calls the telework posture. And they've made it clear that OC remains fully functional and is conducting examinations off-site through correspondence. And then if it's absolutely necessary to be on-site, they could, in theory, send somebody to a firm's physical location. In addition, the SEC has formed a cross-divisional market monitoring group, which is an amalgamation of mostly the division heads of the various divisions to work together to assist the Commission in actions and analysis related to the effects of COVID and to respond for requests for information. What we found is throughout this period of time, everybody is just hungry for getting additional detail. And so the goal behind the cross-divisional market monitoring group would be that would be a resource for the dissemination of information and we're continuing to monitor activities as guidance comes out. Some enforcement activities and actions of note of recently. I did want to take one step back here to talk about a case that came out in 2019 from the Second Circuit, so New York. And this is just, it was a case of note that has come up since the most recent presentation that we gave. But the reason why it's important is because it shows a willingness of the U.S. Department of Justice to expand, in effect, the rules for insider trading. So typically, if you've got an insider trading case, you're going to have, if the SEC is taking action, it's going to be under Title 15 of the U.S. Code. And for a long time, since the 1980s at least, the Supreme Court, through a variety of rulings, has in effect held that in order for there to be insider trading, you need to have the tipper, the tippee, and then there needs to be some kind of personal benefit to the person who's making the tip. Well, in this case, U.S. versus Blazak, there was a change to the Medicare reimbursement rates that got tipped. And there were trades based on the new rates that were going to be coming out that resulted in $7 million in gains. And there was a question about whether or not disclosing government information would actually somehow constitute a benefit on the person who was providing the tip, if there was property involved that they had used, or how it would fit in with the rubric of the statutory scheme, because the U.S. Department of Justice, who was bringing the action, didn't just allege a violation of Title 15, which would be the Exchange Act securities fraud claim. Instead, they also brought a claim under Title 18, under a theory of embezzlement, saying that the tipper, in effect, took property of another, because it was the Medicare reimbursement rates that belonged to the government, and gave them to somebody else. And even though the person who gave the property of the government didn't really receive a benefit from taking that property, like in a straight embezzlement case, if you take the money, then it's easy to say, okay, you've gotten a benefit. But if you're taking somebody else's property, that's really just information and then passing it on. The Department of Justice's position was that there wasn't a personal benefit, and that didn't matter for purposes of securities fraud under Title 18. And the important part of this decision is that the Second Circuit agreed with the U.S. Department of Justice. There was a strong dissent, but for right now, it appears that under Title 18, there doesn't need to be a personal benefit under the theory of embezzlement if for insider trading. So it's going to be a different standard if you've got a criminal investigation from the U.S. DOJ versus, say, a civil investigation or action from the SEC. So just putting that out there. Next, though, we can look at some more enforcement actions and case developments of note. This is a new action that was just instituted in the last couple of weeks against Kinetic Investment Group, which is a Florida-based investment advisor, which engaged in, apparently over the last several years, allegedly, an unregistered security offering, along with an alleged misuse of funds. And in effect, what was happening was an executive of the fund was not doing with the funds what they said they were going to do. So there would be investments that were supposed to be made, and in reality, what the allegations say are that the executive was using the money to for personal loans and also to invest in companies that the executive held separately. So this is a good point to raise I got a couple of good points to raise. Number one, it shows that even in the last couple of weeks, when we've got more of these run-of-the-mill investigations that you would usually see in normal times, we know that we are still seeing those same type of normal activities even now, given the current telework posture the SEC has. But number two, it's a reminder of, if you've got the documents that you are following, make sure that you have in form. Make sure you are following those documents, because otherwise it does no good. And make sure that you are doing what your documents say. Next, we have a couple of settlements. One is with Canal Capital, where the commission says Canal broke their own P&Ps by not keeping a list of restricted securities. And what was interesting about this case, Canal is based out of Idaho, and the only person at the company, apparently, that had the ability to affect trades was the CCO. And so when the CCO was out of town for a couple of weeks on a vacation, nobody in theory could actually be causing any types of trades to be made or any kind of expenditures of the capital that the company had. And that then led eventually the SEC to notice that the policies and procedures that they had in form were again not being followed in functions. So they were able to end up to settle the case for $150,000. We saw an administrative proceeding with Monomoy Capital. This was also just a couple of weeks ago. And in that particular case, it was a private equity fund advisor who charged the portfolio company's fees for its operations group services without fully disclosing the practice and conflicts. So this again is similar to one of the actions that we would usually see in regular times, where there would be an investigation into whether or not fees are being disclosed. And in this particular case, there was a management fee, and then there was a second fee for an operations group services. And it wasn't clear in the disclosure documents how the operations group services fee was being charged and then allocated. And this resulted in a censure and a disgorgement of those fees, together with penalties and interest totaling over $1.9 million. So the real takeaway from all of these is that even though it's not business as usual, it's still kind of business as usual, at least when it comes to respect of the typical enforcement activities and priorities that we would expect to see from the SEC and from OC at this time. And with that, I am happy to move this on to anybody who might have any questions.
So I was just pointing out that that the request was that we needed to provide the slides from today's presentation for continuing education requirements, and that we are not planning on posting them or making them public, but that we will be happy to provide them to anyone that sends us a request. Any other questions that anyone would like us to answer? One thing that I would follow up with is on the delivery requirements. Jarell, if you could maybe just let us know and clarify on the delivery after filing, when it needs to be posted on the website, and when if they don't file on June 30th, what date do they need to file or deliver to their existing clients?
Sure. So the Form CRS for advisors who are already registered or have a pending application, that's the May 1st to June 30th filing window for actually getting the form with the SEC. And that filing is done as either an other than annual amendment or part of the initial application or annual updating amendment. So those are kind of the two options there. And then as far as getting it to existing clients and customers is concerned, the instructions to the form actually tie it to that filing window as opposed to the date of filing. So you need to deliver the Form CRS to existing clients and customers within 30 days after the date by which you are first required to electronically file your relationship summary with the SEC. So if you file on the earlier end of that window, you may actually have more than 30 days between filing and delivering it to customers. But on the other hand, if you've already filed the form, there may not be any reason to delay going ahead and getting the form out to existing customers. So it would be, in any event, no later than 30 days after June 30th.
Great, thanks for clarifying that. Chris, do you mind just commenting on the PPP loans and whether or not that private funds have access to those?
Sure. So the upshot is going to be most likely not. And that's going to be in connection with some of the guidance that came out, where I believe The deadline actually to, if somebody received it, to repay it is going to be May 7th, which will be tomorrow, if I'm not mistaken. But in effect, it's going to be if there are speculative investments, or really there's a series of guidance that came out that in effect would say private equity in general will not be able to get PPP loans, and there will have to be repayment if they were already received.
Okay, thanks for clarifying that. I think that goes along with the investment advisors. If you, now knowing that you will have to disclose that on your Form ADV, you have until May 7th as well to return those funds. If you have any questions on how that process works, we do have some very good lawyers that have been working on that very issue in our office, and we're happy to connect you or provide you with the information. Jarell, we have one more question, and I'm just going to throw this one over to you if that's okay. But what should we be looking at for returning employees to our offices?
Sorry. So this is not specific to investment advisors. Just generally, I think it's important to have a plan consistent with the governor's guidelines. So if you're in Oregon, Governor Brown's guidelines. If you're in a different state, you'd want to follow the guidelines in your state. And then we are suggesting that firms consider alternating work at home days, limiting communal area access, requiring mask use, increasing cleaning standards, including sign-in sheets in some cases to make it easier to track who all is in the office, and other steps. I am not a labor and employment attorney, but our labor and employment group is offering a webinar in the next couple of days to focus on getting back to whatever the new normal looks like with less teleworking and more people in the office. And so if anyone in attendance is interested in hearing that information and or attending that webinar, please reach out, and we'd certainly be happy to provide information on that as you're preparing the plan to return to the office to the extent that we can.
Thanks, Jarell. And I think that webinar is supposed to take place tomorrow at 10 a.m. So if you are available and you have the interest, we can definitely provide that to you. It is probably also available on our website, and you could go to the website and follow the link there. But we would like to thank you all for joining us. I think that is the extent of our questions. And so we are going to hang around for just a couple minutes in case anyone else has any questions. Again, you can submit them on the Q&A portion down on your web Zoom meeting, whatever it is, the little pop-up button that says Q&A. So we're happy to answer any of those questions. You can follow up afterwards, and we will hopefully be able to connect with you all soon. Please stay safe and look forward to hearing about everything that you guys are up to.